All righty, I have one thing to call the October meeting of the Board of Zoning Appeals to order. If we could have a roll call from the clerk's office.
Patricia Williams, Jamie Rowe,
Present.
James Corcoran,
Present.
Ashley Williams. I see that you're present.
Present.
Okay. Cecil Anderson, Terry Kerr, David Harden,
Present.
Rebecca Longmire,
Present.
Robert Thompson.
Present.
You have 6 members present.
Okay, and if I could have a reminder from the law director's office, I think since we're proceeding by Zoom, we need to make some particularized findings. Is that correct?
That is correct. Governor Lee's executive order, I believe it was 60, requires that the board find that meeting electronically is necessary to protect the health, safety, and welfare of Tennesseans in light of COVID-19 outbreak, subject to the several conditions. I was just checking the Knox County Health Department's webpage this morning, and it appears that there is still a trend line of increasing cases, and there are there remain additional health department rules and regulations involving COVID-19. So I think that finding could be made.
Based on that representation from the law director's office, I guess I would move that we find that having this meeting via Zoom is necessary in accordance with the Governor Lee's executive order. Do I have a second?
Second. Jamie.
And if we could have a roll call vote.
Patricia Williams is out. Jamie Rowe.
Yes.
Ms. Rowe votes aye. Mr. Corcoran.
Aye.
Mr. Corcoran votes aye. Mr. Williams.
Aye.
Mr. Williams votes aye. Mr. Anderson is out. Ms. Kerr is out. Mr. Harden.
Aye.
Mr. Harden votes aye. Ms. Longmire.
Aye.
Ms. Longmire votes aye. And Mr. Thompson.
Aye.
Mr. Thompson votes aye. All members present voting aye.
Thank you.
I'd like to add Patricia was just in the lobby. She's now let in. She just missed her turn to vote, but she's now in, just FYI.
Thank you.
Welcome to the meeting of the Board of Zoning Appeals. Members are volunteers from each county commission district who do not receive compensation for their work on this board and training they attend. As a quasi-judicial body, we avoid ex parte conversations and conduct our business in accordance with the Open Meetings Act. I'm the chairman, James Corcoran. I believe our vice chairperson is out today. Perhaps Mr. Harden, could I put upon you to help me keep track of any of the electronic hands that go up?
Absolutely. Be happy to.
All right, thank you. I'll try to do so myself, but I could always use an additional pair of eyes. And if, for the record, if any of our representatives from Knox County and our metropolitan government could identify themselves for the record.
Yes, Knox County Codes is present. We have in the room with myself, Kelly Vaughn, and Kim Jernigan. We also have Jim Snowden, our senior director, and Leo McCamera, our head plans reviewer, on in a separate account.
And hello, this is Mike Reynolds with Knoxville, Knox County Planning.
All right, did we miss anybody? Okay, now our voting procedure requires 5 positive votes for any motion to be approved, regardless of number of board members that are present. Do we have 7 members present now, counting Ms. Commissioner Williams? I believe so. First up would be the approval of the minutes, which I believe were sent out via email. Would anyone make a motion to approve the minutes from last month?
Make a motion to
I
approve.
so move. Rebecca Longmire.
Yes,
Second.
yeah. Mr. Harden, would you want to second Ms. Longmire's motion then?
Yes.
Okay. We have a motion and a second to approve the minutes. If we could have a roll call vote, please. I don't know if someone from the clerk's office is trying to talk. You might be muted.
I'm sorry. I wasn't. Can you hear me now? I'm sorry.
Now we can. Thank you.
Miss Williams. Vote for the minutes, Miss Williams. Okay, I'll come back. Miss Rowe.
Aye.
Miss Rowe votes aye. Mr. Corcoran.
Aye.
Mr. Corcoran votes aye. Mr. Williams.
Aye.
Mr. Williams votes aye. Mr. Anderson is out. Ms. Kerr is out. Mr. Harden.
Aye.
Mr. Harden votes aye. Ms. Longmire.
Aye.
Ms. Longmire votes aye. Mr. Thompson.
Aye.
Mr. Thompson votes aye. Ms. Williams. Are you voting on the minutes? And no response, so.
Ms. Williams, I don't know if you can hear us, but we can't hear you. Mr. Law Director, would that be appropriate to consider present not voting? Or, oh wait, I'm seeing a video feed now. Let's wait a second. Or at least her box moved. Ms. Williams, I don't know if you can hear me, but we still can't hear you, I don't think. No. I guess we could consider that present not voting.
Okay.
That's fine.
Well, that we have 6 members that voted audibly, so couldn't hear Miss Williams, so.
So I believe the minutes are approved. The Knox County Board of Zoning Appeals is authorized to grant variances here other matters by the Tennessee Code and the Knox County zoning ordinance. Specifically, these laws prescribe parameters required to grant a variance. For an improvement, these grounds for variance rest upon the applicant. For each matter, the clerk will read the request on the record. I'll then ask if the applicant is present and ask if there's any opposition or other speakers who wish to present. You do not have to come forward at this time. Once we determine speakers for each item, we'll call on governmental agencies such as Knox County Codes, MPC, or engineering to make statements regarding facts pertinent to the property and background of the request. Board members may ask questions of governmental agencies once they've made their statements. We'll then call for the applicant to come forward and state their name and address for the record and present evidence, reasoning supporting grant of a variance. If there's no opposition, applicants have 10 minutes to present their case. If there is opposition, the applicant in opposition have up to 15 minutes to present their case. After the applicant's presentation, board members may ask questions of the applicant, then call opposition or other parties who then have up to 15 minutes to speak. This 15-minute applies to all parties. So if there are multiple parties that wish to speak, please figure out how you will divide up your time beforehand. Finally, there'll be discussion of the case by the board, during which time the commissioners may ask further questions of the parties that have already testified, and the board will make any necessary determinations as appropriate. By our bylaws, an applicant an initial hearing may request a deferral of 30 or 60 days without prejudice. In the event of a deferral of an application or a failure to appear, any funds may be heard in the record of the meeting where the application may pose that item on the agenda. Now for the swearing in the speakers, if the law director could please address those intending to give any testimony today.
This will be an admonishment to tell the truth. If you intend to give testimony before the Board of Zoning Appeals, you should know that your testimony should be the truth, the whole truth, and nothing but the truth. And thank you.
Okay. Now, prior to proceeding the next matter, my understanding is that item 4A, which is the applicant or the request for an appeal regarding a property located at 4937 Y Springs Road, which is a residential treatment facility. My understanding is that by agreement of both the opposition and the party applying, that's being continued to the next meeting, is my understanding, by email. If there's anyone here present who was not part of that agreement to move that forward 30 days that would like to preserve any objection or any support on the record, is there anyone here that could so signify? I don't believe I see anyone. Okay. And Mr. Sanders, correct me if I'm wrong, but since that was done by agreement, does there need to be any vote on that issue?
No, it can be done without objection.
So unless there's any objection and hearing none, that will be continued to the next scheduled meeting. Now, if the clerk could read the next matter on the agenda, which I believe is item 5A, which is a deferred request from last month.
This is a deferred request of Wayne Klein with Hodges, Dowdy, and Carson for waiver to appeal the August 13th, 2020 Planning Commission approval of file number 8-SB-20-C and 8-D-20-UR concept use on review for Bluegrass Road subdivision. Properties located at 09125, 9127, 9141, and 9145 Bluegrass Road, 0 Coyle Lane, and 1540 Pine Springs Road. The CLT map is 144, parcels 11101, 111, 115, 116, 117, 11202, part of, and map 144, group NN, parcel 003. The property is on PR in the 5th Commission District.
As we've heard a good deal about this at the last month's meeting, but given that I think this is the only matter on the agenda, I was looking at perhaps giving each side approximately 10 minutes, unless someone has some really strong feelings to the contrary. And as I think we've got some additional information from Mr. Davis regarding the Blue Line Stream information that I think we had discussed he was going to provide at the last meeting, and given that it's his application, my thought would be is if Mr. Davis could go first, if he wants to walk us through any of that information that was provided, and then if the appellant could go second, and Mitch for each side.
Can y'all hear me? Scott Davis.
I can hear you.
Scott Davis, P.O. Box 11315, Knoxville, Tennessee 37939. At the last meeting, we were asked to provide a streamlined determination, which has been done. This is a moot point and should be stricken from the record.
Do you feel that you need any additional time, Mr. Davis, to present anything else, or is that?
No, I'll yield to Mr. Klein because he has to prove otherwise, and I'll yield to Mr. Klein and would like to reserve the rest of my time.
Thank you. Mr. Klein?
Good afternoon, Commissioners. I'm Wayne Klein from the law firm of Hodges, Dowdy, and Carson, 617 Main Street, Knoxville, Tennessee, 37902. I'm here representing the landowners and the homeowners in the Pine Springs subdivision and the Williford subdivision on their appeal of Mr. Davis Masana Development's use on review and development plan, as was approved by the MPC in their August meeting. Your jurisdiction and authority, as we discussed last month in this appeal, is derived from Article 6.50.07 of the Knox County Code of Ordinances, which states in pertinent part, any person, firm, or corporation aggrieved by any decision of the Metropolitan Planning Commission relative to uses permitted on review may petition the Board of Zoning Appeals to consider same. And last month, my clients and I laid out the problems associated with the use on review and the consent plan before you. And this board must consider it de novo, which is Latin for from the beginning. And your job under subsection B of Article 6.50.07 of the ordinance is either to affirm, modify, or impose restrictions regarding the location, character, or other features of the proposal, land use, or the building as you deem advisable in the furtherance of the general purpose of the Knox County ordinance. So to begin with, it's not a moot point. We need to consider this de novo, and we need to consider the appellant's application, and that's my clients. My clients repeat their request that this board modify or send this concept use on review plan back to MPC to prevent Pine Springs from continuing to back up and to prevent homes in these two subdivisions from flooding. I might add to also prevent homes that appear to be proposed to be built in this proposed subdivision from also flooding, because this body continued the hearing to allow the applicant to perform a blue line stream determination according to the mandates of the Knox County Stormwater Ordinance, which defines a blue line stream as any stream that is shown on a 7.5-minute USGS quadrangle map, unless determined otherwise by the Tennessee Department of Environmental Conservation, TDEC. You have in your packets my letter dated September 18th, 2020, with an attached 7.5-minute USGS map showing the Pine Springs Blue Line Stream, which provides the presumption that the Pine Springs is a blue line stream. And since the September 2020 BZA meeting, the applicant has performed a stream determination report of the Pine Springs at the Bluegrass Road site. Christy Renfro from TDEC has sent correspondence concerned with the jurisdictional determination of the Geo Services jurisdictional determination of this water feature. Ms. Renfro states in her October 19th, 2020 correspondence that there are various other water features on site which may potentially also be considered jurisdictional waters of the United States, and any alterations to them should only be performed after consultation with the Army Corps of Engineers. The results of the Geo Services investigation indicate a wet weather conveyance. Due to primary and secondary stream indications, a secondary score of 8.5 was calculated using a reasonable amount of effort. And the Appendix A to their report illustrates the Pine Springs water resources and demarks it with a blue line through the proposed Bluegrass Road subdivision, which is also demarked with a red line demarking the parameters of the subdivision on page 2 of that appendix. As you can see from the overlap in Appendix A with the concept plan on applicant's use on review submission, there are several houses in the concept plan that are proposed to be built right on top of this water feature before it flows downhill and eventually flows under Bluegrass Road and around Williford subdivision. You also have in your packets photos showing the flooding that periodically occurs on Bluegrass Road from the backup of water from the Pine Springs downhill flow. This flooding has occurred intermittently and importantly reoccurred the past 2 years in a row during heavy or extended rains. And the concept plan with houses proposed to be built over the top of this water feature causes grave concern to the homes downstream in Pine Springs, and particularly to the owners in the Williford subdivision whose houses are downstream from Bluegrass Road, where the pooling and flooding is most prevalent and obvious. And my clients request this board modify applicant's concept plan to not allow homes or construction to occur on top of or within 25 feet either side of the center of this wet weather conveyance. And we thank you for your consideration in the plight of these homeowners, their citizens, their Knox County taxpayers. Thank you for your consideration.
Thank you. Mr. Davis, since you indicated you wish to reserve some of your time, I guess, for rebuttal, do you have anything further to add after that?
Two things. I think it's obvious that Mr. Klein is trying to confuse the matter. We were asked, and so I will respect the request of Mr. Sanders. Is this a basis for an appeal? Yes or no?
I don't think that we can just sort of administratively or as a matter of law dismiss the appeal. I think this is a de novo hearing. I do agree with Mr. Klein in that respect. his client's claim to be aggrieved, and so he has a right to appeal. And this is a de novo hearing. So the question is, does the board want to affirm, overrule, or modify the determination of the Planning Commission? You can consider the Planning Commission's action, and staff is here to answer any questions that you might have. This is a use permitted. So if it meets all of the requirements of the zoning ordinance, then it ought to be approved. If you have concerns that there's some sort of perceived violation of the zoning ordinance, then your deliberations should focus on that, and you should consider any sort of conditions that would be appropriate to mitigate those perceived violations. But I think I don't believe that there's a way that we can simply say this is not a proper appeal and move on from it.
It's my understanding the appeal was made under the auspices that this was a blue line stream. It has now been determined to be a wet weather conveyance. So I would yield to the Knox County Engineering Department. Are there any ordinances that prevent us from building within a 25-foot buffer or requiring a 25-foot buffer on a wet weather conveyance and not waters of the state?
Leo, are you here? Can you answer that, please?
There is.
Yeah, there's no buffers from a wet weather conveyance. There would need to be some kind of an easement that would be determined by your engineer, Folger McIndoe, and reviewed by our department to check for the sufficiency of the width.
So if I understand correctly, once it was determined to be a wet weather conveyance, which we've gotten confirmation from Geotechnical Services and confirmed by TDEC, that in fact it is not a blue line stream, so there are no buffers required. And thus the basis for the initial appeal was based solely on the fact that this could possibly be a blue line stream, which we in fact have now determined it not to be. So the fact that it was determined not to be a blue line stream and it is not protected waters, there are no buffers required. So the impact, so there was nothing done inappropriately by the Planning Commission. Is that correct, Mr. Sanders?
I'm not here to pass judgment on what the Planning Commission did. This is in the hands of the Board of Zoning Appeals at this point.
Yes, sir. So we were asked at the last meeting to provide to this board a streamlined determination, which we have now done, and it's been confirmed by TDEC. Therefore, the basis of the appeal, the entire basis of the appeal, should be moot and waived based on the evidence provided and confirmed by TDEC.
You will recall that my appeal was also based upon the flooding, commissioners.
Just to try to make sure we don't get off track here, Mr. Davis, I think what Mr. Sanders was kind of hinting at, this being a de novo appeal, my understanding is by our ordinances on a de novo appeal, you don't get to rely on any presumption based on the MPC or the planning commissions. So one of the things that before you kind of rest, I want to make sure that you feel that you've done is that you feel that you've demonstrated that I think the language in our ordinance is that the proposed plan or use is in harmony of the general purpose and intent of the zoning ordinance and with the general plan and sector plan, and is reasonably necessary for the convenience and welfare of the community is the language that's in the ordinance. And also on a de novo appeal, I think we're also still required to make a determination that if there were some sort of adverse impact on the character of the neighborhood in which the site's located, that it'd be appropriate to deny it. So you just want to make sure, between today and the last session, if you feel like you've that sort of proof has been presented, I think that's just trying to provide a little bit of guidance, just so we don't get off track here into legal arguments. That we need to make sure that you feel that proof's before us before you stop.
Yeah, and I appreciate that. To my knowledge, we have met all the requirements for within all the ordinance guidelines. And this is within character for the area. And we will not increase and or produce adverse impact to anyone downstream, because as per our engineering design guidelines, we cannot do so. And so to answer your question, yes, in my opinion, we've met all the criterion. There's nothing ordinary or extraordinary in this. And I think the folks with the engineering department can confirm the same, as well as the folks with the planning department.
Okay. Then if you don't have anything further to add, I think it's appropriate for the board to kind of move to our deliberation phase. If anyone from the board has any questions, let's see. Oh, got some hands up. Mr. Thompson, I see that you've got your hand up.
I believe Mr. Williams had his hand up first, so I'll defer to him.
Okay. Mr. Williams?
I was about to say the same to Mr. Thompson, but in essence of time, this is to codes and then over to Mike Reynolds. The information provided by TDEC to codes, does this suffice? The inquiries, does this bring up any additional information or solidify the information as far as codes is concerned?
It solidifies for us that it's not a stream and it's a wet weather conveyance. And I would add to what Leo added earlier, that if it's a stream, those can't be relocated. So, they would impact where the homes go. Being it's a wet weather conveyance, that can be moved to the back of the lots, and just the swell will have to be designed to accommodate the flow off of the Pine Springs neighborhood. So that's the big difference between a stream and a wet weather conveyance. The wet weather conveyance can be relocated and convey the water elsewhere. The stream cannot be.
Codes, do you see any other requirements for this project?
There'll have to be a detention requirement, for the stormwater runoff, which
Sure.
we've not seen yet. Since we're only conceptual, we've not seen the design plan for the site yet. But there will be requirements for detention, but they'll have to meet pre and post development flows. So the downstream flooding, it shouldn't increase any downstream flooding.
And then I'm going to throw that over to Mike Reynolds, if you don't mind. Mike, same questions?
Yes, again, this is Mike Reynolds with Knox County Planning. So with the submission of the stream determination, that satisfies the Planning Commission condition on the concept plan, which isn't, it's not part of the use on review, but it's part of the concept plan that satisfies the condition that they submit that study and that the study shows that it is not a stream. Yeah.
Thank you both. I'll let Mr. Thompson speak.
Thank you. I want to go back to the discussion I raised last month, and that is that the application for this should have included a preliminary stormwater plan, but it did not. That is, I refer to the subdivision rules 3.06.a.2. Can we bring those up? I had asked Ms. Jarnigan if we could display that. Hello?
Give us 1 second. We're trying to get it shared.
Okay, so while we're waiting, to me, okay, and then scroll down to 2. Okay, there. The concept plan application shall include the preliminary stormwater management plan. So that was not done yet. So to me, Planning Commission did not enforce its own rules. And because of that, the opposition was denied a meaningful opportunity to comment on this application. So regardless of Blue Line Stream or not, there still has to be this preliminary management plan. And as far as I can tell, that still has not been submitted. So, and as I mentioned last month, to me, that is grounds for overturning the Planning Commission's approval. But short of that, I would propose to meet the intent of this, I would propose that if we're going to affirm the Planning Commission's determination, that we impose a condition that there be a preliminary management plan and that the neighbors be given a meaningful opportunity to comment on it. Now, as I recall from last month, I believe Mr. Reynolds mentioned that the preliminary plan does not need to be elaborate. It does not need to be a big thing. But I think that if we can impose that condition as I've suggested, I think the intent of the whole scheme here would be satisfied. The neighbors would have their opportunity that they should have had to begin with. But as it is, the neighbors, I think, were met with kind of a blank stare when they raised the flooding issue last month, or at the Planning Commission hearing. The engineering department was not able to give a meaningful response. As a result of that, the neighbors have had to go through a lot of rigmarole. They've had to incur attorney's fees. They've no doubt endured a lot of anxiety. So I urge very strongly that we impose a condition as I've suggested. Thank you.
For the record, Mr. Thompson, can we clarify which set of rules we're looking at?
We're looking at the Knox County, the subdivision rules 3.06-.A.2. And my understanding is that, those apply technically to the concept plan, which from everything I've heard, the concept plan and the development plan are essentially the same thing. So we're reviewing the use on review, we're reviewing the development plan, which is the same thing as the concept plan, and therefore it should have included this preliminary stormwater plan.
Okay. Anything further?
Not at the moment, thank you.
I see that Ms. Longmire has her hand up, but real quickly before we get away from that point, I wanted to have a quick question for our law department. Mr. Sanders, that rule that was just cited, is that something that's binding upon the Board of Zoning Appeals?
Right. I would caution the board not to look to the subdivision regulations as a basis for denying a development plan approval. The subdivision regulations and the process for approving a concept plan are separate from the development plan approval process and the development plan. Although many of the documents and many of the processes and information will be the same, it's not appropriate to pick and choose which regulations you want to apply. The regulations to be applied here today are those for the development plan approval under the zoning ordinance, and not the concept plan approval procedures under the subdivision regulations.
Thank you. Ms. Longmire?
Yes, I have a question for Mr. Davis.
Yes, ma'am.
Are you there, Mr. Davis?
Yes,
Okay. Do you have plans for relocating this wet weather stream? Do you have plans? What sort of plans do you have to help mitigate the flooding that occurs?
Yes, ma'am. The engineering plans are being worked on as we speak. As a general rule, you don't go into the engineering side until and unless you have your concept plan approved. But the engineering plans will accommodate for the wet weather conveyance, and we are required, as per Knox County Engineering and as per TDEC, to contain the water on site. We cannot discharge water at a rate faster than what was prior to our development. So that is all controlled by Knox County Engineering and TDEC. And that's done with our detention ponds and our flowage requirements. So we cannot discharge water downstream at a higher rate than what it was prior to us starting the development. I think that can be confirmed by Knox County Engineering, that in fact is the case, that we're required to hold that water back, which will prevent us from doing additional flooding.
Thank you, Mr. Davis. To carry on to engineering, because we have photographic proof of flooding in that area, what are the plans that county engineering has to maybe help lessen the problem caused by the flooding?
Yes, Ms. Longmire. We currently haven't seen the development plan to know what the flow rates are. Once we get those, it's our intention that if there's a problem downstream, we'll enlarge the pipe size under the roadway, which it looks like maybe that's what's going on. The pipe under the road is too small. So if once we get the development plan, we can look at those numbers. We will make the downstream improvements necessary to prevent that roadway from flooding.
Okay, well, the question I have is, the flooding is there. Are you not going to, if this plan is not approved, will you not do anything to help mitigate the flooding?
Well, one of the issues is that the pipe design under our roadway is for a 25-year storm. The photos that were taken happened back in February, which was like a 125-year storm. So, even if we upgraded the pipe to a size to meet today's standards, that storm would have still overwhelmed those. That storm was just far exceeded any design standards we have for our pipes under our roadways.
I understand that, but considering that there has been an increase in the amount of rain that we've seen, and that the pipe that was put in is no longer efficient. I mean, not for 125 years, but a 25-year storm doesn't leave you much leeway. Is there no plan to maybe increase the pipe under the road, even no matter what happens here today?
We can look at that. We were waiting on to get Mr. Davis's design plan, which will tell us how much flow is actually coming off that site. So, in essence, his engineer is going to do the work for us and tell us how much flow is going through that pipe, and then we can size it accordingly. If the development doesn't go through, we can certainly look at that and have our staff engineers size the pipe to ensure it's the proper size. But, the right thing to do is wait until Mr. Davis's plan comes in. We see how much flow is coming, then we can size the pipe accordingly to accommodate the water from his site and what's already coming to it.
So in a way, approving this development might help the community in their flooding problem, because you'll have better information about the flow of water.
Yes.
Thank you very much.
You're welcome.
All right, we've got, I think Mr. Thompson has his hand up, and Ms. Rowe, I see you. We'll get you after we go back to Mr. Thompson.
Thank you. I want to reply to Mr. Sanders. I agree that our job is not to technically enforce the subdivision rules, but once again, we do look at the development plan. And again, the development plan, from everything I've heard and seen, it's the exact same thing as the concept plan. I've heard Mike Reynolds say that. I've heard previous members of the staff say that. If you look at MPC's own webpage, there's a use and review page. The link is knoxmpc.org/commission/use. It says here's what is required for a use and review. It mentions the development plan must include the preliminary stormwater plan. And again, that was not done here. Again, it deprived the neighbors have a meaningful opportunity to comment. But regardless of that, whether it's technically within our purview or not, given what's happened here, given how the Planning Commission did not follow its rules, I ask again, we impose a simple condition if we approve this, if we're going to uphold the Planning Commission's determination. I just ask that the neighbors be given a meaningful opportunity to look at the preliminary stormwater plans. If they do not get that, my understanding is they will have no more opportunity to comment, because once we get to the design plan, there's no requirement for public participation on that. So I don't think it's much to ask. Just give the neighbors some meaningful input. Let them submit any information they have that they feel is not being properly considered. Thank you.
Ms. Rowe, I believe you're next.
Yes, I really agree with Mr. Thompson regarding this. Also, I wrote down what Codes was saying as they were saying it, that they have not seen the development plan. Well, now I'm really confused. If they haven't seen the development plan and that's what we're supposed to be considering regarding this, then how could we make that determination?
Yes, Ms. Rowe, we've not seen the engineered plan. We've seen the development plan, the conceptual plan for the site, which has the preliminary stormwater layout on it. The preliminary stormwater plan shows us the general location of the stormwater pond, how the stormwater is going to be routed. But until we get the engineering plans from the engineer, which actually has the numbers, the calculations for the runoff, the pond size and that data, we really don't know what type of runoff is going to come from the site.
So when you said that you have not seen the development plan, that was, you misspoke?
I probably misspoke. We've not seen the engineered plans yet. Yes, we've seen the development plan that you guys are seeing at this conceptual stage. And I don't know if it's misspoke. It's just, I guess, different lingo for different types of plans.
Well, I certainly agree that at the very least, we ought to add the condition about the stormwater plan.
I'm not seeing any other hands up from the board. Mr. Sanders. Mr. Sanders, you're muted. I see your hand up.
I apologize. The development plan for this project is attached to your agenda packet, and it was attached last month to your agenda packet. I will reiterate that whether you do it directly or indirectly, applying the subdivision regulations to Mr. Davis's application for a development plan approval is inappropriate. The information to be provided for a development plan are contained in the zoning ordinance in a PR zone, section 5.13.15B. And it requires essentially a development plan showing the use or uses, dimensions, and location of proposed streets, parks, playgrounds, school sites, and other open spaces, with such other pertinent information as may be necessary to determine the completed arrangement or use, which makes it desirable to apply regulations and requirements different from those ordinarily applicable under these regulations. Prepared and sealed by an architect, et cetera, et cetera. If you should apply these requirements, if you apply any requirements. I mean, you have to apply these requirements. I don't want to imply that you shouldn't apply requirements, but if you're going to apply requirements, they have to be these, not the ones from the concept plan review process.
Hey, Daniel, I'm going to add too, that is a difference, you know, a development plan can be done by an architect or a surveyor. So an engineer is required to do the design work for the stormwater pond and that type of stuff. So that's why we don't see those numbers until we get to design phase, which is the next step of this process, where we'll get a design plan and engineering. We'll review the calculations, and then we'll either approve or we'll make have them make revisions to the plans based on our comments.
Ms. Longmire, I see that you got your hand up, but I think Ms. Rowe was physically raising her hand up a little bit first. Ms. Rowe, do you have an additional?
Yes, I just wanted to say that since it is a use on review, we can go with in harmony and do no adverse impacts and that kind of thing. And I think that flooding would definitely come under an adverse impact on the neighborhood. So I think it is something we can consider, whether we do it saying the subdivision regulations, but we can do it under the use on review process.
Ms. Longmire?
First, I'd like to hear Mr. Sanders respond to what Ms. Rose said about doing the use on review process.
That's fine. Mr. Sanders, do you want to butt in? And you're muted.
There is some authority that you have to consider the impact on the neighborhood, but you have to do that with the idea that whatever decision you make must be based on substantial and material evidence. You know, and I'm not here to weigh the evidence for you, but if you're going to talk about flooding, you need to have some sort of proof, substantial and material proof, that the proposed development is going to have an adverse impact in relationship to the flooding. The proof that the properties currently flood, I don't think speaks directly to the issue of whether the development will have an impact on that or not.
Thank you, Mr. Sanders. I really don't think we can deal with flooding caused by a 125-year flood. That's beyond the scope of what we deal with. And I know we have pictures, but as Mr. Sanders said, that's really not proof that the development is going to cause further flooding. To me, because the application dealt with the fact that staff and commission erred in not determining Pine Springs as a blue line stream, thereby requiring appropriate buffers, it is not a blue line stream. Therefore, to me, I think the appeal should be denied, and I make a motion to that effect.
We have a motion. Do we have a second?
Second.
Okay. We have a motion properly seconded. Accordingly, it's coming on us to further discuss this motion. I see Mr. Sanders, is your hand still up?
No, it's not.
Okay. And Ms. Longmire, your hand still up?
No, it's not.
Okay. Well, I guess I'll take a moment to chime in now that we have a motion before us. I'm looking at, again, I read a little bit from this during Mr. Davis's time. And this is talking about approval or denial of a use on review, which I believe is what governs us on a de novo hearing. And I think it's really important that, first of all, that we listen to the legal advice we've been provided by the law department, and that we're here on a de novo hearing, which means we don't get caught up in the process of what happened below. That means that a de novo means an entirely new hearing, which means we focus on giving these folks a fair hearing based on the proof that has been presented to us, based on what we've heard. And my understanding of the standard is what we're supposed to be looking at is, first of all, if the proposed plan or use is in harmony with the general purpose and intent of the zoning ordinance, and the general plan and the sector plan, and is reasonably necessary for the convenience and welfare of the community. Now, I'm talking about whether or not this is in accordance with the general plan and the sector plan. I think it's pretty darn clear from the record that the density of the housing is within the appropriate level for the planned residential zoning that it's currently in. I think that's consistent with both the general plan and the sector plan. With regards to reasonably necessary for the convenience and welfare of the community, obviously we're dealing with a subdivision, we're dealing with housing. I believe that housing is necessary for the welfare of the community. We do live in a community where, where Knox County's population is ever increasing. We are going to need to find places where folks can live. It's not our job to exclude people unless there's a good reason to. That section I was reading from goes on to say that the Planning Commission, I think this also applies to us, can deny use on review where the above cannot be shown, or where it can be shown that approval would have an adverse impact on the character of the neighborhood in which the site is located. And I think in line with what Mr. Sanders has been saying about material proof, now there's some proof that there is currently some flooding, but I think for us to deny Mr. Davis's ability to build this planned development, we would need to there would need to be some proof before us that this, if we're talking about flooding, that there needs to be some actual tangible proof that this is going to cause increased flooding. I don't believe we've had any experts testimony presented before us that this is somehow going to increase flooding. In fact, the folks from codes have said that there's a process in place that will be down the line to ensure that any flooding is not exacerbated. In fact, it sounds like there's a potential plan down the road to improve some of the drainages to potentially alleviate, but I don't think we need to go so far as to find that. We just need to find that there's not proof that this flooding is going to be exacerbated based on what's before us here today. So I'm really concerned when we start getting caught up in whether or not MPC did or did not follow MPC's rules, or what was or was not presented before MPC. We need to focus on what's actually been presented before us. Accordingly, I believe I support the motion that's currently before us, and would open up to comment for anyone else on the board. Not seeing any other hands. If no one else has anything to add from the board, I think it's appropriate for us to continue to a vote, unless anyone wants to chime in for further discussion. Assuming I'm not missing anybody here, I guess I would ask that the clerk's office go ahead and take a roll call vote.
Before I begin the roll call, who made the second to the motion? I'm not sure if it was Mr. Williams.
I believe it was Mr. Hardin.
Mr. Hardin, thank you. Okay.
And just to clarify, I believe a affirmative vote would be to, I guess, affirm the decision of the Planning Commission. Is that correct?
To me, it is, because it says the reason was it erred, and we said it did not err. So we are affirming the Planning Commissions.
Okay. And with that clarification, I think we're ready to vote.
Ms. Patricia Williams,
Can you hear me?
yes.
Okay, great. Deny.
So you're voting yes to deny? The motion is
Yes,
to deny. So you,
correct.
okay. Ms. Williams votes aye. Ms. Rowe,
Now I'm confused.
Yeah, exactly.
Yeah, I thought she meant deny the, are you saying deny the appeal?
Well, according to Commissioner Corcoran, He said to affirm or deny.
Okay, let's phrase it in positive terms, just so it's
Okay.
clear. An I vote is to approve the development, which would affirm the decision of the MPC.
Correct.
So your vote is aye then? Are we clear?
No. It is to deny.
It's a nay vote then, is what you're saying?
It's a nay vote.
Okay, Ms. Williams votes no. Ms. Rowe?
No.
Ms. Rowe votes no. Mr. Corcoran?
Aye.
Mr. Corcoran votes aye. Mr. Williams?
Aye.
Mr. Williams votes aye. Mr. Anderson is out. Ms. Kerr is out. Mr. Harden?
Aye.
Mr. Harden votes aye. Ms. Longmire?
Aye.
Ms. Longmire votes aye. And Mr. Thompson?
Nay.
Mr. Thompson votes no. You have 4 aye votes and 3 no votes.
And Mr. Sanders, for the record, can I know and understand the basis for the denial and what the facts are to deny? 'Cause unfortunately, from this point, we have no other course except to go to court.
Well,
For the
no,
record,
Mr. Davis, we have to have 5 affirmative votes to actually
Act on.
approve or deny. So we've not made a decision yet. We can either continue to discuss, or someone can make a different motion at this point in time.
yes, sir, I apologize for interrupting.
But I agree with Mr. Davis. I would like to know on what foundation we have for denying it.
I don't know, Mr. Sanders, if you think it's appropriate to weigh in on this. I don't know if we're required to make particularized findings of fact, but
You're not required to make findings of fact. You're required to make a record, and the video is being recorded. All the documents will be in the record with the clerk's office. Under the Royal Properties case, you guys are required to act on applications before you. And in order to do that, you have to have 5 positive votes to carry a motion, whether that motion be to affirm, overrule, or modify the decision of the MPC. And when you have a motion that fails for lack of a sufficient number of votes, then you can consider additional motions on the same item. And you should do that until a motion gets a sufficient number of votes. Now, with members absent, you may reach a point where you feel that you're at a deadlock and that you might need to wait until some other members get here. And maybe that requires to put this off for a month. But you're going to have to vote until you come to a decision. Coming to a decision for a body like this means to have 5 affirmative votes for a motion.
thank you.
Yes. Mr. Thompson and Mr. Williams both had their hands
I
up.
was just trying to understand.
Oh, I guess, Ms. Longmire, were you not done?
No, I just said I was just trying to understand the reasoning behind denying what the reasoning was. But if that's not an appropriate question, that's fine.
I think folks certainly get to
Well,
argue and make their case that for any appropriate other motions.
if I may, I think that's an absolutely appropriate question among the board members during their deliberations. This is your all's opportunity to persuade one another to your side. And if there are members who question the reasoning of members who are on the other side, then this is the time to have that out.
That sounds rather come out swinging.
Mr. Thompson.
All right, for example, Miss Williams.
Hi. I was attempting to ask, what was your vote? I thought your vote was no. Who was the third no vote, Ms. Ellis? Who are the 3 no votes?
The 3 no
was Mr.
votes
Thompson.
are Miss Patricia Williams, Miss Jamie Rowe, and Mr. Robert Thompson.
Mr. Thompson, I do apologize.
Yeah,
Miss
Mr.
Williams,
Thompson's hand up.
what was your reason?
May I speak now?
I'm going to continue to recognize Ms. Longmire, who I guess looks like she's trying to yield her time to Ms. Williams. Ms. Williams, if you're interested in responding to Ms. Longmire's question.
Well, it seems that we're between a river rock and a running stream here. I feel that the community currently has a problem that the city has not rectified or taken care of. Not sure of the impact the project is going to have on the community. The information needed for the community or even for us to make a determination has not been done, does not have to be done. And when it is done, it'll be too late to do anything about it. So I really almost want to pass on voting altogether, because I feel we've been put in a position to make a decision based on information that's not available or should have been available previously to MPC. So I feel like I'm on the hook here because it just seems so many things are absent or out of order, should I say.
Thank you, Miss Williams. I appreciate that. That's all.
Okay, Mr. Thompson.
Thank you. I would vote aye if we can impose a condition such as I mentioned, which is to require that the neighbors have a chance to input at least at some stage on the water plan. So unless Mr. Sanders says that we lack authority to impose a condition such as that, I would, we can phrase it, we'll have to work out the exact phrasing, but that's what it would take for me to vote aye. So I guess I would ask Mr. Sanders, does he say we do not have authority to impose a condition to require public input further?
I hate to answer your question with a question, but Mr. Thompson, what sort of plan is it that you would like to see?
Well, again, I would like to see the neighbors be provided with some kind of preliminary. It does not have to be the final engineering. It does not have to be the final engineering. In fact, it would be preferable before we get the final engineering. At some point, what we would call a preliminary plan to show the neighbors, here's what we think we're going to do, whether to reroute the wet weather conveyance or whatever, and to let them comment on, well, was this a 125-year flood or was it something less than that?
Well,
so I don't have the details on. We could work that out, but some kind of preliminary input prior to the final engineering.
Well, I think maybe it's appropriate to consider that at some point there will be a full engineered stormwater plan for this development. And certainly Mr. Davis's, if this is approved, Mr. Davis's engineer will prepare that and submit it to Knox County Engineering and Public Works for review. And it will be a public record. And when Engineering and Public Works completes its review, if the plan is approved, then the community would have an opportunity to appeal that decision, because this board has authority to hear those kinds of disputes where there's where it's alleged that there have been some sort of error in a determination made by an administrative official. And the appeals from stormwater get brought to the Board of Zoning Appeals. Whether that comes through, normal administrative processes or through the stormwater ordinance, it would definitely, there would be a right to appeal the determination. So if Mr., like hypothetically, if Mr. Davis has an engineer to submit some sort of deficient plan, and a deficient plan is approved by Engineering and Public Works, and that would be a basis to disagree with that determination and appeal it. But I don't think the board has authority to impose conditions that are above and beyond what the zoning ordinance would require for a development plan. Part of what a development plan is to sort of get a project moving, meet the minimum requirements of the zoning ordinance, and then put it into other administrative settings that approve these other things that have to do with stormwater and more specific road design. And, there are any number of additional administrative hoops that Mr. Davis will have to jump through. And one of them is stormwater. And like I say, that process has its own safeguards for the community if they disagree with something that is to be done down the road. So the preliminary stormwater requirement appears to arise out of the subdivision regulations, not the development plan approval. And without some sort of substantial and material proof that says that the development plan as it exists causes some sort of adverse impact on the community, then what basis do you have to do that?
The development plan is incomplete, still is incomplete.
In what way? I mean, I'm just trying to aid the board in getting specific.
I mentioned, I apologize to everybody. I really hate to draw this out, but I feel strongly about this being an issue of MPC skirting its own rules, denying the public a chance to comment. The public has a hard enough time giving meaningful input on anything. There's short notices, there's not much information, there's unfamiliarity with the process. I think it's essential that MPC follow its own rules. So I'm going to, again, I apologize to everybody for drawing this out, but can we bring up, I mentioned earlier, I referred to MPC's, can we bring up this webpage, knoxmpc.org/commission/use on review? Can anybody bring that up? I want everyone to see that. And by the way, there's the use on review, the words use review.
Well, while you're looking for that, while we're waiting for that, I don't feel there's any need for an apology, Mr. Thompson, Commissioner. If we're to springboard or take the baton from
Ms. Williams, I hate to interrupt, but there were a couple other people that were in line with their hands raised.
Oh, I'm sorry.
And,
I didn't see them. I
Sorry
can't
about
see
that.
everybody's face. Sorry.
Mr. Thompson, were you done?
Hey, Bob, where did you want us to go so we can pull that up?
knoxmpc.org/commission/use-on-review.
Again, /use/review.
Use/on/review. I don't mean, I mean use-on-review.
We're trying to share, but I think we're having some technical difficulties.
It says I'm screen sharing right now.
Can you guys see the document?
Yes.
We just can't see it.
For some reason, we can't see it here, so we're not for sure how to scroll on it.
Get them minimized. There we go. All right, go ahead.
All right, Mr. Thompson, where do we need to go on this?
It's toward the bottom. There's a list of things that the development plan has to include. Keep going. Keep going. Here we go. Materials, it must be
Right there.
preliminary, see, preliminary drainage plan. Material,
Keep going more. Right there.
now if you go back up to where it says materials to be submitted, go scroll back up a little bit. See, it says 10 copies of the development plan.
Yeah,
That-
there.
Where it says 10 copies, that merely reinforces the idea that the development plan is the concept plan, because it's the concept plan that requires 10 copies. So it's pretty clear to me that planning committee has always treated these two things as the exact same thing. And so if the public is required, if the public is supposed to have an opportunity to comment on a preliminary plan, it flows through to the use and review process.
Mr. Thompson, are you done?
I'm done. Thank you.
Okay. Let's see. Mr. Williams, I think you were up next. I could be wrong, though.
No, thank you, sir. I was going, a couple of things. And this is, I voted to approve it, and this is kind of why. Back when I chaired the City of Knoxville Neighborhood Advisory Council, and as well as when I was president of the West Hills Neighborhood Association, we would always schedule time, or I would always suggest for communities to reach out to the developers and have conversations with them before going to MPC, City Council, what have you. Obviously, this is a little late for that, but it's my understanding we are to look at this as the way it is brought to us today, and try not to get wrapped up in the feelings of what happened in the past. And I'm trying to do that. And based off the last meeting, the biggest questions were, and I want to thank Mr. Davis for getting that information done in a timely manner. But as I understand it today, Mike Reynolds, speaking on behalf of MPC and the Knox County Codes, does not see any issue with this plan, as well as what Rebecca Longmire added to earlier was this could alleviate flooding in that area. Now, there's flooding all over Knoxville, whether it's a 125-year flood or 50-year flood or 25. I just don't, based off those pictures of being a 125-year flood, when you consider North Shore Drive around Ebenezer was underwater for a month. And stormwater is doing things to alleviate that. But that's why I'm voting to prove or to let Mr. Davis continue with his development. But I would suggest for all communities down the road, when you find out that there is a development coming in your area, reach out to the developer before it gets to that hand. And thank you.
Do you have a quick question for Mr. Reynolds? Mr. Reynolds, is there preliminary drainage shown in any of the package that we got?
Yes, the preliminary drainage that is shown on the plan is where the retention is located. Sometimes we'll get like where the stormwater pipes will be located, if there's any type of easements that are needed for the stormwater pipes, or if there's easements needed for drainage across the property. Usually those things get nailed down during permitting, so it's not unusual to see the preliminary drainage or stormwater plan primarily be the detention, like where it's located, because that can greatly impact the road design and the lot layout. So, yep. So this is what we would typically see from a preliminary standpoint.
Is there anything in that preliminary drainage plan that would support the assertion that this is going to cause some increased flooding?
No, there is not.
Okay. Let's see. Mr. Williams, is your hand still up? Okay. I'm going to go with Miss Williams then. I think I'd cut her off once before. And then Mr. Harden will come to you next, and then Ms. Rowe. Ms. Williams?
Well, this is just really difficult for me. Not that I'm grading the work of MPC, but as I said, it's our job to go from where they're, to take it from where they leave off, or where their stopping point is. And let me just say, where I live, there's two houses on the end of my block. One has been there for, the second from the end has been there for years, probably 40, 50. And the first one on the corner was built about 5 or 6 years ago, I think. And neither of those residents have ever been able to use their backyard because there is some type of flooding or creek or something coming through there that keeps it wet, and it continues to be wet. And of course, when it rains, it's just wet. It's just a flood. But the house, the newest house that was recently built, the 5-year-old house or so, I spoke with her some time ago, and I noticed that the city is up there now. They've dug into the ground and they're following the trail of water or creek or whatever it is underground there. They dug it up and following it and attempting to rectify that situation. But this one, the second house has dealt with that all along. And the newer house is dealing with it as well. But she told me that there was something that was supposed to be done before building the house there that was required to be done. And they built the house anyway and didn't do it. And this situation for me just helps me to see how that happened. It just helps me to see how that happened. Somebody didn't do something and no one can make them do it. And by the time it gets to it's just out of order, I feel. And I can't, it's building, I just can't do it. I can't do it. Because if someone was supposed to do something that I'm to hook up to, and you didn't do it, there's nowhere for me to go. And so far, no one has provided information in any way regarding this situation, the water, the stream, I haven't heard it yet. And, but I can see the results of it at the end of my block right here. I'm done.
Mr. Harden, I believe you were next.
I voted to approve the NPC, and I still think we should. I think Mr. Davis would have done the Blue Line Stream plan or studied it. He didn't do it because we asked him to it or because Mr. Klein asked him to do it. He did it because that's in the normal process of doing development. There's a Blue Line Stream there. He checks it out and makes sure it's not. He did it early for us, basically. He would have done that anyway. Same thing with the stormwater stuff plan. That will be done once the complete plan is submitted, development plan is done. That will be done by Knox counties. The flooding that's there now has nothing to do with him at all. And Knox County's already said they're going to work on that after they see his complete development plan. They can't address it now because they haven't seen the complete development plan. I think we need to approve it. I say Mr. Davis has done everything he said he was going to do in a timely manner. We cannot pay attention to what the MPC's done. They sent it to us. It's our decision to do it. We need to say yay or nay and move on with it. We can't hold up another development. So I think we should vote yes.
Ms. Rowe, did you have your hand up?
I did, thank you. The reason I voted not to go ahead is kind of twofold. First of all, I have a lot of experience with flooding and that kind of thing over a period of time in Knox County and Knoxville. Spoken to a lot of people. I've been to a lot of sites where people have lost their homes and been flooded out. That being said, I went back and read all the letters that were sent in. And I know Mr. Sanders says we can't really use that as proof, the photos and everything, but the best predictor of future behavior of water is past behavior. And if they have flooding now, I've never seen a development go in and then everything is much, much better. And a real good example of that is at Fountain Gate above us on Tazewell Pike. Tazewell Pike is closed several times a year. You may not even realize that because that little bridge almost washes out real close to Fountain Gate. Water problems perpetuate. And I'd really like to hear from Mr. Klein if that's not out of order. Would that be okay?
That's fine. Was there something specific in addition that you wanted him to add?
I would just like to hear his take on us deciding on something on a use on review. We have the right to turn down a use on review. So I guess that's what I would like to hear from him.
Thank you, Commissioner. You have the right to approve, to turn it down. You also have the right to modify under your rules. But the first thing I want to say that I didn't want to bust in because I think it's inappropriate, but the proof before you is not that this flooding occurred just one time in a greater than 100-year flood. This has occurred 2 years in a row and then in prior years several times, but not in a row. But 2 years in a row, not just at that one flood, which was a greater than 100-year flood. The second part about this is the concept plan shows that houses and the construction will be built right over the top of this wet weather conveyance. And so I asked you in my words before to overlay the concept plan on the Blue Water Stream where it runs, which is not a Blue Water Stream, but the weather conveyance where it runs, to show that this concept plan shows development and construction over the top of the wet weather conveyance. It doesn't show it's going to be moved. You should be able to understand the concern of the neighborhood at this point in time. And so I'm recommending or asking you to modify the concept plan such that construction doesn't take place that way, or ask Mr. Davis to modify it and bring it back to you. I understand Commissioner Thompson's request that the neighborhood have input or public input before it gets to be too late. The important point is, once it reaches a certain point, the community, the taxpayers who have land maybe adjacent to, who believe they may be negatively impacted, have no further say. And this is a community, the Pine Springs community and the Williford community, who has said, we want to do something affirmative. We want to be proactive so that it doesn't flood out somebody's home down across Bluegrass, or it doesn't impact negatively on the Pine Springs neighborhood. They're not against Mr. Davis's development. That's never been their position. And they don't want to foreclose his ability to do it. They just want to see it to the point where no flooding or flooding is controlled or dealt with prior to it being too late. I want to say it right, so excuse me.
Ms. Rowe, I believe you had yielded your time to Mr. Klein. Did you have anything to add?
The only other things I would say is one of the people that spoke at the other meeting was an engineer who spoke about the water. So I think we have heard from an expert, and I think the photos speak for themselves. I really would like to make a motion that we modify, to ask for a modification of the plan to move the homes, or whatever you want to call it, out of that area and provide a buffer zone in the area of the wet water conveyance.
We have a motion. Do we have a second?
I second.
Okay, we have a motion properly seconded. Discussion. I did see some hands up, but let's, if folks could make sure if they're going to keep their hands up right now, that it's to discuss the motion that's currently before us. Mr. Law Director.
I just wanted to chime in. Not only don't I think you have the authority to do what it is you're moving to do, but I'm familiar with the processes involved in grading permits and the stormwater manual, and the way that engineering can chime in on this too. A wet weather conveyance may indeed be altered and moved to the periphery of this subdivision in the process of a grading permit. And if you attempt to locate the wet weather conveyance as it exists today, I've never seen that done, number one, because it's oftentimes that a developer gets into a piece of property and it has a wet weather conveyance or a ditch, and it's not in a convenient place to achieve the development plan. That wet weather conveyance may be moved and improved even, and trying to tie the developer's hands at this stage in the game is really, I think, putting the cart before the horse. I don't often get into these things, but I really don't think that at this point, knowing that wet weather conveyances are often located on other parts of the property from where they exist prior to the development or the grading permit. I don't know what the basis for this is. Yes, there's a wet weather conveyance on the property. It could be moved and located and or improved in the process of administering a grading permit, for instance. And the engineered stormwater plan may say, well, it would be better to move it into the backyards of these houses rather than to have it go in front yards of the houses. I mean, there's no way that you can make that determination here today, that it's more beneficial to have it in this present location than it would be to be engineered into another location.
Hey, Daniel, Steve here. I would concur with you. I think if you place a buffer, you severely hinder the design process of what the engineer can do. And I'm going to ask Leo to speak a little bit about the wet weather conveyances and how we move those. But I feel as though as you place a buffer on this conveyance, it doesn't allow them to move it and maybe get the conveyance to the back of the properties and convey the water more efficiently than what's going on now. So Leo, can you speak to that, please?
Yeah, the wet weather conveyance, it has to be picked up where it enters the property, and it has to leave where it exits the property. In between, it can be moved. It could be moved to the back of the lots. It could be piped in place all the way through. So we don't know what he's going to do with it at this point. So I really don't see the point of buffering something that may not be in the same location.
Also, establishing a buffer on something that there's no regulation that requires a buffer may be far in excess of your authority. I mean, you're saying the streams require buffers, and that's a regulation that we're all familiar with. Wet weather conveyances do not require buffers, and to impose that requirement at this stage is I think in excess of your authority, and that's I guess the meat of what the issue that I have with this condition.
Next to recognize Mr. Williams.
I apologize. This is to codes as well as Mr. Davis. I would assume for codes that as Davis progresses through this project, you two would be working hand in hand, mitigating what's best for the property, for the water coming off the property. As you stated earlier, no more water can come off that property after construction than before construction. Is that correct?
Go ahead, Leo. Can you speak to that, please?
The peak flow rate can't be increased for a range of storms from the 1 year to the 100 year. The volume of water always increases when you develop property. The idea of the detention basin is to meter that increased volume over enough time such that the peak flow rates aren't increased.
So fair to say then, by continuing with this development, utilizing the detention pond, this would not create additional watershed off that property.
The volume of water will increase. It always increases whenever you develop property. However, they have to hold it back. They have to provide an area to pond that water up and meter it through small openings such that the peak flow rate is not increased.
Perfect, thank you.
Mr. Thompson.
Thank you. I appreciate the thinking behind Ms. Rowe's proposal, but I don't think we have enough information before us to vote on that. So I don't, well, again, I appreciate your thoughts. I don't think I can support that. I would offer as an alternative, I guess I would ask I also want to mention on the question of whether or not the development plan we saw does include the preliminary stormwater information. There is something in the graphics, I guess, that shows where some of this would be, but my understanding from last month was no, it did not actually include what you might consider a preliminary plan. But regardless of that, I want to ask one possible way out of this. I would ask Mr. Davis if he would agree voluntarily, a very small request. Would you agree to discuss with the neighbors before the train leaves the station on the engineering? At some point initially, would you agree to have further discussions with the neighbors, let them give you the information they have, give them a rough idea of what your plans are before they're developed so far as to be unstoppable? And I would ask Mr. Klein if Mr. Davis agrees to that, whether Mr. Klein would be satisfied with that. And if Mr. Davis will agree to that, then I would change my vote to say, yes, I affirm the action as it happened.
And Mr. Thompson, I have absolutely no problem with that at all, because the last thing we want to do is adversely impact somebody's property, because then they have the right to come after me personally. And in addition, we put up substantial bonds for these detention areas and to make sure we do control this, that won't be released until we do everything properly. So yes, sir, I will vow to you today on the record that yes, in fact, I would be happy to meet with the potential affected property owners and then also help them go to Engineering and Public Works to see how we can mutually and cooperatively help and fix any problems that pre-existed and any problems that we would potentially cause. Yes, sir, I'd be glad to do that.
All right, well, then as I said, I would, based on that commitment, I would change my vote to affirmative.
Okay, based on that, right now, the motion that's properly seconded is to amend the order. It would be appropriate if someone wants to make a substitute motion. Mr. Williams, I see your hand up.
Okay.
I would like to make a substitute motion to approve the development upon Mr. Davis speaking with the community, having input before, as you said, the train leaves the station.
Mr. Law Director, does that language pass legal muster?
I think I would understand that as a motion to affirm the decision of the Planning Commission.
And I'm sorry, did we have a second?
Second.
I did. Longmire.
Okay, Ms. Longmire's motion by Mr. Williams, second by Ms. Longmire. If we could have a roll call vote, please. An affirmative vote is to affirm the decision of the Planning Commission, which would be granting the use on review.
Ms. Williams?
No.
Ms. Williams votes no. Ms. Rowe?
No.
Ms. Rowe votes no. Mr. Corcoran?
Aye.
Mr. Corcoran votes aye. Mr. Williams?
Aye.
Mr. Williams votes aye. Mr. Anderson and Ms. Kerr are out. Mr. Harden?
Aye.
Mr. Harden votes aye. Ms. Longmire?
Aye.
Ms. Longmire votes aye. Mr. Thompson?
Aye.
Mr. Thompson votes aye. Five aye votes, 2 no votes.
Accordingly, the motion is passes and the decision of the Planning Commission is affirmed. Do we have any additional matters before the board today?
Mr. Chairman, should we discuss the meeting next month, whether it's in person or Zoom?
That would be a very good idea. Mr. Law Director, do you have any guidance on our process on that decision?
We do not have current authority to have a electronic meeting in November. Governor Lee's Executive Order 60 expires at the end of the month, and he has not extended that. So we'll be meeting in person next month.
That settles that, I think. Do we need to make any votes on that, Mr. Sanders?
No.
Mr. Chairman, and just a reminder, next month's meeting is a week early. It'll be November the 18th in the large assembly room.
Okay. Let's see, Mr. Thompson, I see your hand is up.
What if the governor extends the order?
Mr. Law Director, would we have a process to address that?
We could poll the group with sufficient, if he extends it with sufficient time for us to get notice out of the meeting.
Just for a general sense, about how much time would that require as a general rule?
Has to be posted a week before the scheduled meeting.
Can we count on the Law Director's office to keep us apprised of that?
We'll keep you apprised.
Thank you. Mr. Williams, your hand appears to be up in the, at least on the participants menu. Is it, okay. I don't see any further hands up. Anyone else? Then I believe we are adjourned. Thank you, everyone.
Have a good evening. Whew.